the indictment and the information. The indictment and the information. It's like Tango and Cash. Only Tango's information and, indictment is clearly Cash. Rule 7. A. The indictment. An indictment shall be a written statement presented in open court by a grand jury to the district court which charges the commission of any crime by an alleged offender. 2. Requisites of the indictment. Every indictment of the grand jury shall state the crime charged and essential facts which constitute the offense. It also should state, I, that it is presented by a grand jury. I, that the defendant is identified therein either by name or by the defendant's pattern, chemical structure of genetic information, or described as a person whose name is unknown to the grand jury. Either by name or by the defendant's pattern, chemical structure. By their DNA or described as a person whose name is unknown. I guess the best description possible. 3. I. The offense was committed within the jurisdiction of the court. Within the jurisdiction of the court. Or is triable therein. 4. That it is signed by the foreman of the grand jury and the prosecutor. B. The information. An information shall be a written statement signed by the prosecutor and filed in the court having jurisdiction over the offense charge, alleging that a person committed the criminal offense described therein. Requisites of the information. Number 2. Requisites of the information. The information shall be deemed technically sufficient and correct if it can be understood therefrom. I, that it is presented by the person authorized by law to prosecute the offense. I, that the defendant is identified therein either by name or by the defendant's pattern, chemical structure of genetic information, or described as a person whose name is unknown to the informant. I, that the offense was committed within the jurisdiction of the court or is a triable therein. IV, that the offense charge is set forth with such degree of certainty that the court may pronounce judgment upon a conviction. 3. Information after preliminary hearing, waiver, or dispositional hearing, and information may be filed without consent of the trial court having jurisdiction for any offense against anyone who has either I, failed to request a preliminary hearing in the county pursuant to Rule 5. I had a preliminary hearing or dispositional hearing and has been bound over by the county court to appear in the court having trial jurisdiction. 4. When a defendant has been bound over to the trial court pursuant to Rule 5A.4.3, the felony complaint, when transferred to the trial court, shall be deemed to be an information. If it contains the requirements of an information. Direct information. C. The prosecutor may file direct information if 1. The prosecutor obtains the consent of the court having trial jurisdiction and no complaint was filed against the accused person in the county court pursuant to Rule 5, or 2. A preliminary hearing was held either in the county court or in the district court, and the court found probable cause did not exist as to one or more counts if the prosecutor states an intention to proceed in this manner. The bond executed by the defendant shall be continued and returnable in the district court at a day and time certain. If a bond has not been continued, the defendant shall be summoned into court without the necessity of making a new bond. The information shall be accompanied by a written statement from the prosecutor alleging facts which establish that evidence exists which for good cause was not presented by the prosecutor at the preliminary hearing within 21 days of defendant's first appearance. Following the direct filing, the defendant may request an evidentiary hearing at which the prosecutor shall establish the existence of such good cause. Or 3. The prosecutor obtains the consent of the court having trial jurisdiction in the complaint upon which the preliminary hearing was held, and the other records in the case have not been delivered to the clerk of the proper trial court. Number 4, the case was dismissed before a preliminary hearing was held in the county court or in the district court when one is required, or in other cases before the defendant was bound over to the trial court or otherwise set for arraignment or trial, the information shall be accompanied by a written statement from the prosecutor stating good cause for dismissing and then refiling the case. Within 21 days after defendant's first appearance, following the direct filing, the defendant may request a hearing at which the prosecutor shall establish the existence of such good cause. The prosecution may also submit the matter to a grand jury. Number 5, the case was dismissed after the district or county court found probable cause at the preliminary hearing, if one was required, or in other cases after the defendant was bound over to the trial court or otherwise set for arraignment or trial and before jeopardy has attached. If such case was originally filed by direct information in the district court, the prosecution may not file the same offenses by a felony complaint in the county court, but the prosecution may charge the same offenses by filing a direct information in the district court, or may submit the matter to a grand jury, and the case shall then proceed as if the previous case had never been filed. The prosecution shall also file with the direct information and with the felony complaint a statement showing good cause for dismissing and then refiling the case. Within 21 days of defendant's first appearance following the filing of the new felony complaint or the direct filing of the new information, the defendant may request an evidentiary hearing at which the prosecutor shall establish the existence of such good cause. D, repealed. E, amendment of information. The court may permit an information to be amended as to form or substance at any time prior to the trial. The court may permit it to be amended as to form at any time before the verdict or finding if no additional or different offense is charged and if substantial rights of the defendant are not prejudiced. F, surplusage. The court on motion of the defendant or the prosecutor may strike surplusage from the information or indictment. G, bill of particulars. The court may direct the filing of a bill of particulars. A motion for a bill of particulars may be made only within 14 days after arraignment or at such other time before or after arraignment as may be prescribed by rule or order. A bill of particulars may be amended at any time subject to such conditions as justice requires. H, preliminary hearing, district court procedures. Number 1, in cases in which a direct information was filed pursuant to Rule 7C, charging 1, a Class 1, 2, or 3 felony, 2, a Level 1 or 2 drug felony, or a Class 4, 5, or 6 felony, or a Level 3 or 4 drug felony if such felony requires mandatory sentencing or is a crime of violence, as defined by 18.1.3406, or as a sexual offense under Part 4 of Article 3 of Title 18 CRS. A preliminary hearing is authorized. Either the defendant or the prosecutor may request a preliminary hearing to determine whether probable cause exists to believe that the offense charged in the information has been committed by the defendant. However, any defendant accused of a Class 4, 5, or 6 felony or a Level 3 or 4 drug felony who is not otherwise entitled to a preliminary hearing may request a preliminary hearing if the defendant is in custody for the offense for which the preliminary hearing is requested, except that upon motion. Why are we doing this all over again? God damn it. Except that upon motion of either party, the court shall vacate the preliminary hearing if there's reasonable showing that the defendant has been released from custody prior to the preliminary hearing. Any person accused of a Class 4, 5, or 6 felony or a Level 3 or 4 drug felony who may not request a preliminary hearing shall participate in a dispositional hearing unless otherwise waived for the purposes of case evaluation and potential resolution, except upon a finding of good cause. The request for a preliminary hearing must be made within 7 days after the defendant is brought before the court for or following the filing of the information in that court and prior to a plea. No request for a preliminary hearing may be filed in a case which is to be tried upon indictment. Number 2, upon the making of such a request or if a dispositional hearing is required, the district court shall set the hearing, which shall be held within 35 days of the day of the setting, unless good cause for continuing the hearing beyond that period is shown to the court. The clerk of the court shall prepare and give notice of the hearing or any continuance thereof to all parties and their counsel. Number 3, the defendant shall not be called upon to plead at the preliminary hearing. The defendant may cross-examine the prosecutor's witnesses and may introduce evidence. The prosecutor shall have the burden of establishing probable cause. The presiding judge at the preliminary hearing may temper the rules of evidence in the exercise of sound judicial discretion. 4. If from the evidence it appears to the district court that no probable cause exists to believe that any or all the offenses charged are committed by the defendant, the court shall dismiss those counts from the information, and if the court dismisses all counts, discharge the defendant. Otherwise, or subsequent to a dispositional hearing, it shall set the case for arraignment or trial. If the prosecutor believes the court erred in its finding of no probable cause, this ruling may be appealed pursuant to Colorado appellate rules. Such a ruling shall not constitute good cause for refiling. 4.5. A dispositional hearing is an opportunity for the parties to report to the court on the status of discussions towards disposition, including presenting any resolution pursuant to 167302. CRS 167302. The court shall set the dispositional hearing at a time that will afford the parties an opportunity for case evaluation and potential resolution. Number 5. If a request for preliminary hearing has not been filed within the time limitations of subsection H1 of this rule, such a request shall not thereafter be heard by the court, nor shall the court entertain successive requests for preliminary hearing. The order denying a dismissal of any or all the counts in the information after a preliminary hearing shall be final and not subject to review on appeal. The granting of such a dismissal or any or all of the counts in an information shall not be a bar to further prosecution of the accused person for the same offenses. Upon a finding of no probable cause, the prosecution may appeal pursuant to Rule 7H4, may file another direct information in the district court pursuant to Rule 7C2, Rule 7C2, charging the same offenses, or may submit the matter to a grand jury. But in such cases originally filed by direct information in the district court, the prosecution may not refile the same offenses by a felony complaint in the county court. 5I. Motion for reverse transfer hearing upon indictment in cases commenced by indictment. Any motion under section 19.2.517.3a CRS 19.2.517.3a to transfer the case to juvenile court must be filed within 7 days after the defendant is brought before the court for or following the filing of the indictment in that court, and prior to a plea except upon a showing of good cause. CRCP 7.